I did some research into Ripple, and I saw that they had an incredible leadership team. I saw they had an incredibly impressive board. But most importantly, I think that they're, as far as I could tell at the time, and actually sitting there today, I think it still holds true. It's the only company, I think, in this space that has truly married the promise of blockchain and crypto technology and applied it to solve for a real world problem. So I took the lead, and 4 years on, I have never looked back. And I think if I had not done this, I would have regretted it for the rest of my professional career. But it is the future. I mean, it is the future. And as a lawyer, to get to work in an industry where you are literally, I know that, like, I can't believe I just said literally, but where you are literally defining what the laws, rules, and regulations are going to be for a brand new technology for a generation or generations to come. Oh my God. I mean, to have that opportunity is absolutely, it's an incredible opportunity.
Yeah, it was the internet lawyers in the 90s.
Absolutely. This is the internet of 1995.
Why does this technology matter? Why does what you're working on in digital assets, why should anybody care?
We don't really know what that future is going to look like, but we do know that this is going to be generational changing. What the internet essentially does now is allows us to access and transmit information. What the internet doesn't allow us to do is to transmit value, right? If I want to transmit value, I still have to go to old rails to do that. And those old rails are controlled centrally by large banks or other large institutions. So I think when you're talking, and I'm looking at it through a financial lens, when you think about blockchain and crypto, the promise is that it allows you to actually instantaneously transfer value the way you instantaneously transfer information today, and to personally own your value in a way that is not centrally controlled. Now, what does that allow you to do? What is the promise of that? What is the future of that? I can tell you what it looks like currently and how Ripple has developed a commercial application for that. But I think it would be a fool's errand to predict what it's going to look like in 10, 15, or 20 years.
I think that's right. We just don't know. We can't even imagine it. I would never have imagined the things that we have now when I was in law school in, the early aughts. I didn't even have a cell phone.
That's right. Neither did I. I remember the first time I saw a BlackBerry. I was like, oh my God, what's that? But I do think, I do think it will, the next generation, our children, it is going to be the tokenization of everything, the tokenization of value, the tokenization of information, which I think will allow folks to kind of own that value and own their own personal information in a way that's not centrally controlled.
I agree. What are you guys doing? You said you have real life applications.
Sure.
Part of why I'm delighted to have you on this podcast is Ripple is in the headlines constantly. And it's one of those things I think people see but don't really know what you are.
In October, Ripple's going to be celebrating its 10th year anniversary as a company. We're still privately held. It's grown from a very small core group of founders, 3, to over 700 employees now. We're now a global company. We have offices in San Francisco, New York, and Singapore, in London, and Dubai, and Brazil, and Ireland. I'm sure I'm leaving out a few offices, and I apologize for those that I've forgotten. But what we do, and back to what attracted me to Ripple, is Ripple has a real enterprise commercial use case for blockchain and crypto. And the real world problem we solve for is the problem of cross-border payments. If you want to transfer money, let's just say from the US to the Philippines now, you probably have to go to your bank or go online to make a wire transfer. And you put in all of the information, and let's say you want to transfer $1,000 US. You don't know when that $1,000 is going to hit the beneficiary in the Philippines. You don't know the net amount of the Philippine currency that is going to be received. You don't know if they're going to receive $980, $920, whatever, after all cost fees. If something wonky happens in the transmission, you may be sitting there 5-7 days from now and you're getting a call, I didn't get my money. What Ripple's technology allows our customers to do, and our customers, by the way, are financial institutions and banks and payment providers. We're not consumer facing. It allows them to make that transfer on demand. So in other words, if they want to move that, if they want to move that $1,000 from the U.S. to the Philippines on behalf of their customer, they can agree as a sending institution with the receiving institution before the send button is hit virtually on the cost, the FX rate, all of the AML, BSA, data baked in. You get an electronic handshake, you hit send, and within 3 to 5 seconds, that transfer settles, and the value is actually in the account in less than 10 minutes. So that's revolutionary. That's like sending an email. That's like sending money as if you're sending an email today. That doesn't exist other than what Ripple does. There happens to be a pretty major case that's going on right now involving the SEC and Ripple. We're fighting not only on behalf of Ripple, but really on behalf of the entire crypto industry to get that clarity. And so the clarity may ultimately come through the judiciary, not the legislative branch, but we think the legislative branch is a promising route to get that clarity. But again, you need to get it right. All of those customers and all of those payments are with our affiliates outside of the US, Singapore, Dubai, Brazil, London, those other places that I mentioned earlier. Why? Because those jurisdictions provide regulatory clarity for how to operate in the crypto economy. In the US, we don't have that regulatory clarity. We have massive regulatory uncertainty. And that's a problem. And it's scary for folks to get involved because without that regulatory clarity, you're always going to run the risk that the government may take an overly aggressive view that what you're doing is running afoul to laws, rules, and regulations, which have not yet been clearly defined. So the reason Ripple spends a lot of time in Washington, and we've been doing this for a long time, is we don't want to be free of regulation. We're not asking for this to be the Wild West. We want regulation, but we want regulation that is clear, and we want regulation that we can understand, and regulation that we can follow, and regulation that is suited to the technology. So we spend a lot of time with policymakers, number one, educating them. Because it's a really, really complex space. It takes you, years just to understand the vernacular and understand the technology at a workable level. But we spend a lot of time educating. I think the current chairman of the SEC, Gary Gensler, his most recent gig just before he was appointed as chair of the SEC, he taught a blockchain and crypto course at MIT. So I think when he was appointed, I'm not so sure I'd go so far as to say it was Beatlemania, but people, I think, were cautiously optimistic that finally we'll have somebody who's leading an agency that at least understands the technology, that you don't have to go in and have sort of, a blockchain 101 discussion with him. And we thought that that would be promising. And boy, were we wrong. And I think under this administration with the Securities and Exchange Commission, they have refused to articulate any clear laws, rules, and regulation. Their mantra is, we don't need that because we're applying the existing laws. But I think if you take a close look, or maybe a not so close look, what's the only thing that's clear is they're not looking to apply the law. They're looking to remake the law through regulation by enforcement, through enforcement actions. Only Congress can make the law. The SEC, which is the Securities and Exchange Commission, that's in their name, they only have jurisdiction over securities. And securities is defined by statute. It's defined by case law. And I think they're taking a very expansive view of their jurisdiction so they can claim ownership of this massive crypto economy. So I think what's happening, and I know I'm in Washington, I need to be careful what I say so I don't offend people, but I do believe that this is power in politics being elevated over sound policy. I
don't think that offends people. I think that's our state. We're not a state. I think it's our motto.
And investment contracts are contracts for an investment. They represent a right, title, or interest in the issuer. What the SEC's theory is, I was going to say seems to be, but it is that anyone who buys an asset hoping that they can sell that asset at a higher price than what they bought it for. In other words, they're speculating in it. Then we have jurisdiction over that asset. And that can't be the law, because if it is the law, then Exxon's oil potentially is a security. Barrick's gold mining efforts are a security. De Beers diamond industry is a security. Andy Warhol lithographs that are sold by the Andy Warhol Foundation are potentially securities. That's not the law. What the law requires, again, is a contract for an investment. If I sell you an asset and then I have a post-sale obligation that I promise to do things on your behalf after I have sold you the asset, that's a security. If all I have done is sold you the asset, that's not a security. Even if I'm taking efforts because I have a vested interest, because I also own the asset that I sold you, even if I'm taking efforts and those efforts are aligned with your interest, that doesn't make a security under the law. Speculation is part of the markets. You can't have liquidity without speculation. You can't have liquidity in pork bellies without speculation, but that doesn't turn it into an investment. But under the SEC's theory, which is an incorrect theory under the law, they believe that, at least they're arguing that it does, and that's what we're seeking to correct, either through legislation, maybe the most likely outcome, we'll correct it through the litigation.
You have recently filed a motion for summary judgment, which means you're trying to get the court to toss the case against you by the SEC, just based on what you said on its face, the law applies in a certain way. If this is successful, the motion for summary judgment, that's a huge win for the industry because it does give some clarity.
I'm going to repeat what you said. It's a huge win for the industry because it finally gives clarity to the industry about what the limits of the SEC's jurisdiction are. And the SEC, I think, will be exposed for, again, not looking to faithfully apply the law, but what they're doing is looking to remake the law. And I go back to what I said earlier. An agency can't remake the law. Only the legislature can remake the law.
Yes.